So like, okay, so you talk about the Infants Act there. Well, this is sort of an issue that is not only of great interest to me, it should be of great interest to everybody. I didn't, even when I first got involved in this activism, I didn't know about the Infants Act or how it would come into play. But in my research, I was trying to, like in an effort to get myself more educated about what we were doing as a society to deal with all these kids who were identifying as transgender, I made an effort to go out and figure out, okay, so what is the government doing in that regard? Like, what are the policies? What are the recommendations? So I was out researching all of this stuff. And in the course of that research, I came across a document from Vancouver Coastal Health. Let me just see if I can bring that up for people here. This actually, so Vancouver Coastal Health had come out with this document. Basically, it was designed to tell healthcare workers and presumably other professionals how to treat and handle kids who were having gender identity issues. And in reading that document, I noticed one section where it said, basically it declared that there was something called the BC Infants Act. And the BC Infants Act, in their opinion, gave healthcare professionals and others the power to enable minors to do what they called, they called it sex reassignment procedures. So they had just as they had the right to get an abortion without parental knowledge, or get STD treatment without parental knowledge, all these things. They said, well, actually it goes further than that. If we've got a kid who is identifying as the opposite sex, the same BC Infants Act should turn that decision over to the kids. And this was the first I'd heard of that, right? And I looked at that and said, whoa, what is this? Like, that's like bad news. I mean, kids are not mature enough to be making these decisions. But because it was the first time I ever heard of it, I sort of, well, I went out and took a look at the Infants Act itself, and then I screen captured these documents from Vancouver Coastal Health, and I put it on social media. And this was a good 6 months before this case came up with the father who was eventually forced to facilitate his daughter's transitioning. But 6 months prior, I put out a warning on social media. I had much more reach on social media in those days. We won't get into why. But I said, look, the provisions are there. This actually looks like what they're doing now is they are encouraging healthcare workers to facilitate sex reassignment for minors against parental wishes. And the other side of this debate, who were at that time still ubiquitous on my various social media platforms, came at me right away and said, oh, well, it just reads like that, but they would never do something like that. You're just a fearmonger. It's never going to happen. But then, of course, I believe it was late November of 2018, Angelina Ireland came to me with this story of this father, right, who was being forced to transition his daughter. And this was like a key moment for me, like in my activism. As soon as I got the details of this case, I immediately recognized the significance of it, and I said, okay, I need to get out there. I need to interview this guy, because at that time I was still writing for the Post Millennial nationally. So I figured, well, this will make an awesome story. So I went through the processes, brought it out, and started the ball rolling on this whole case, and brought people's attention to the Infants Act, because it was not being discussed in this debate previously. Like, there was the Prince George case that Barbara Findlay was involved with, a lawyer, Barbara Findlay, prior to this, but nobody in the media sort of made a big deal about the Infants Act. The Infants Act actually was involved in that case. I didn't find out until later because the media hadn't reported on it. But once I got the actual court documents, I found out that it was involved, but nobody was talking about it. So
the facts of that case are very similar to the case that you're involved with the appeal court, because again, the father, unrepresented, tried to get court orders, tried to get the court to help him, but he was just overruled, and of course aided and abetted by not only Findlay, but the Infants Act.
So when it came to my desk, I wrote the story for the Post Millennial that got wide readership across Canada. And so other media outlets picked up on it, and eventually all across the globe, really. And the Infants Act has become this notorious thing now. So so tell us maybe what you know about the BC Infants Act in terms of like why and how it came into power. I know that the controversial section, I think, was part of a modification that they made in 1990, I don't know, 3 or something. I don't know what it was, but just tell us what you know about where this came from, what it was designed to address, and these types of things.
So again, the NDP was in power in British Columbia. Mike Harcourt was Premier of the day. And they introduced these major changes through a miscellaneous statute act, which typically that's just for government housekeeping. When that hits Parliament, usually you use the miscellaneous statute act for just minor things that there's not going to be any arguments. And so buried in the miscellaneous statute, which is something we would rarely, never even look at, was this major change now altering the Infants Act. Now, the Infants Act has always been in existence, and we need an Infants Act. There are some children that don't have parents. There are other circumstances that require minor children to have, some governing legislation on who is going to be responsible and for what. But in this case,
do you know when the first Infants Act went into power?
It was in the early 70s, I believe we first saw. But before that, it would always be like underage child. There's always been some laws somewhere in legislation, whether it was a standalone act or not, governing children, right down from, what is parents and all those kinds of things. So this was a major change. And prior to this, children could only consent to medical and health care if they were 18, right? There was this no provision for a mature minor. That's so ill-defined, because who's going to determine what a mature minor is? So the act reworded the Infants Act to accommodate this new mature minor. And if a doctor agreed that the child was competent to understand the risk involved in what kind of medical procedures, then the child could consent without the need for parents.
Okay, and just so, because I'm trying to get clear on sort of the psychology that was driving it initially, and there's a reason why I'm looking at that, right? But I know that the right to get vaccinations was an issue, but was that linked in with this whole thing about Jehovah's Witnesses and blood transfusions and stuff?
It may have been that may have been used as an excuse, but from our involvement and understanding within the medical community, they weren't wanting this. This put doctors in a very precarious position as far as insurance goes and medicals. And I have some of the legal opinions that were formed during that time. So this was more along the line of abortion. Okay, at this point in time, we had a lot of abortion clinics being opened. We had children being taken from schools to get abortions without parents knowing, school counselors. We were seeing a move towards sexually transmitted disease discussion in schools, to the point of where some nurses were giving recommendations to doctors and those kinds of things. So it became, I think, a precarious concern for the establishment, that what if parents started objecting to this? We also know that we were going to start seeing the advent of the vaccines being introduced into the schools with Gardasil to deal with the sexually transmitted diseases. So there were two real propagandist techniques used. One involved the blood transfusions, for crazy religious parents, right? That denied their children services. The thing with that, though, is if the Infants Act gave the power to a child to get treatment, doesn't it make sense that a child then has the right to refuse treatment?
Right.
So that kind of backfired, and I'll give you an example of a very distressing case that came about after the Infants Act came into power. So the other thing, so basically this was to accommodate the move towards giving children birth control pills, abortion, STD vaccinations. All of that was what the buildup was, to accommodate that. At the time, because there was huge public outcry, this was a massive issue in the press. Now, unlike Soji, the media was actually very competent at that point in reporting on both sides and what would come. And, I pulled out some of the headlines from those days, Children's Choice, and there wasn't, this was just every radio station, every talk show host every news was, what was these. So the citizens research in this, so I led the charge on that and started gathering doctors and people. We put out all kinds of information about it. The government said, the heck with it. Premier Harcourt wrote letters to parents that were concerned saying, oh, don't worry, this act will never be used for cosmetic surgery.
Right. Okay. Well, right there.
Sterilization.
Let's bring that letter up right now. And I got this letter from you, and thank you for that. And let's just show people what this letter is. And here it is here. Okay, I'm going to zoom this in. So this letter came from 1993, okay? And I guess some concerned person had written, and I don't know if this was a form letter that went out to everybody, but it said, thank you for your letters in which you commented on amendments to section 16. I believe it's actually section 17. So I think that's our typo of the Infants Act. I would like to outline the reasons why the government of British Columbia introduced these amendments. Minors cannot consent to procedures such as aesthetic, cosmetic surgery, or sterilization. And so this gets into the whole question of why they're using this now for sex reassignment procedures, which involve cosmetic surgery. And really, when you talk about Lupron and puberty blocker or synthetic hormones, these are all cosmetic things, right? That's what they're all about. And when you go into a court, and I remember there was a constitutional debate at one point where they were debating, what the intention was of the people who wrote the document. That's what a judge does. They try to figure out what was the intention of the lawmakers in putting this law into place. So they come to that sort of understanding in their head, and then they sort of rule based on that. And on this one constitutional issue that they were talking about, they were debating what was in the head of the lawmakers. Well, most of the lawmakers were still alive. Pierre Trudeau was still alive. And I was thinking, okay, well, why don't you go ask Pierre, right? Bring him in. He can tell you exactly what it was. But the point is, and they didn't do that, of course. The judges, for whatever reason, actually talking to lawmakers after the fact doesn't seem to be something that's done. But so they're trying to figure out the intention of the lawmakers when they put it into place. And here, in the case of the Infants Act, it seems pretty clear from that letter that the intention of the Infants Act was never to facilitate something like sex reassignment procedures.
I know, and so the intent, but like you say, the judiciary tends to just ignore when it doesn't go along with what the judiciary wants, pertinent information. This clearly would indicate and direct any judge. And, at the appeal court, Harvey Groverman knows this. He was the lawyer for the Crown, because we ended up taking the government to court on this, challenging it. We had the petitioners exceeded. We had 27 doctors. We had 5 nurses. We had social workers. We had teachers. We had 27 petitioners in this, all involved in, real cases involving the implication of this act. That's who was on our list. And Jack Cram, the lawyer for the case, one of the top legal minds in British Columbia and a good friend of mine, took the case on. We slam dunk on this, that not only did the people not want it, but the law upheld our position on it. But the provincial government assigned a judge to the case, quickly booted this individual, Carol Huttard, into power, and she presided over the case. So we knew we would lose at that front. So here's just one of thousands of legal books, right, on the Infants Act when we challenged it. So the petitioners and everybody there. Now, the interesting thing is, even though there was all this public uproar, when it came to funding the lawsuit, and this is what you're very familiar with too, Jen, is that the people don't step up. So when it came to appeal, and we thought we had a pretty good chance on appeal, but we couldn't raise the $50,000. It was only $50,000 back then to do it. And, these are the challenges that we have. So this act still very much remains up for grabs. And I know we're going to talk about a little bit about what needs to be done politically, But, you know, here we have another example of the court ignoring the public outrage. The court ignored in the case involving the father the intent of the Infants Act, you know, that no sterilization, no cosmetic surgery, the two things that the premier of the day, who was responsible for bringing in this legislation, said will not be part of any procedures under this act. They go ahead and say, oh, the heck with it. You know, we're not here to interpret the law or interpret what we're here to just make the law.
We're not here to do our job.
Let me just court party once again strikes, and of course they did that too under you know, the redefinition of family, right? John Kari&Jenn said, you know, no, this isn't supposed to involve same-sex couples, but the court said otherwise, right? So again, my hobby horse for this political round in my life is going to be bringing accountability to the judiciary. And it's a huge job that's going to need a lot of people. So all your listeners, all your viewers out there, we don't have the luxury of not being engaged anymore. Democracy is a gift in our hands. And like you said, Jen, it's a machine that needs to be cleaned out, but it's also one that has to, you know, the people have to learn how to use better. So, you know, maybe if we can smarten up those spark plugs and know what gear we want to go, maybe we'll make a difference. So
yeah, let's talk about this document here. I'm just going to bring this up. This is the one I was talking about earlier.
Right.
This Caring for Transgender Adolescents in BC Suggested Guidelines. Now, this came out in 2006, and it's what you call a peer-reviewed paper, right? There's all kinds of MDs and PhDs and all kinds of people involved there, people that are familiar today, like Wallace Wong was a part of this at that time. But now, I may be wrong, and you can correct me here, but I believe that prior to just recently, when we were talking about the Infants Act, we were not talking about sex reassignment procedures. And this particular document, the reason that I was sort of caught off guard is because it hadn't been part of the discussion. And that's probably because maybe the people initially, when this legislation was passed, and this is where you would know better than I in terms of what was being discussed and what not, never had sex reassignment in mind, and so it wasn't discussed. And it wasn't until this document came out in 2006, it's since been revised, where they started saying, well, you know what, if we sort of look at the fine print of this law, that we can use this for sex reassignment. So is my sort of understanding of it correct? That
you're absolutely bang on, Jen. Never in any of the discussions, the court papers, the affidavits, and I've got boxes of information from our legal challenge. Never in that discussion was something so outrageous as you know, child sex surgery reassignment involved in any of the discussion or debate. It conceptually wouldn't have even been on the radar of the majority of people.
Mm-hmm. Yeah, well, I guess we should I'm always sort of clear to make people understand that, at least in British Columbia, when we talk about sex reassignment procedures, we are talking about pretty much exclusively puberty blockers and pharmaceutical methods, because I think that any sort of sex reassignment surgery is still 18 in BC.
Well, yeah, but we know that people are getting that surgery. We know of a 15-year-old girl who had a mastectomy. This is happening here in Canada. And
the girl in question that you're talking about, didn't she have to go out of the country to get it done?
We don't have all of the details, but we know that the father paid for it himself. You know, good dad that he was, right? So, and I understand that there are some other situations that has transpired. I think in Ontario we have a few that are being looked at right now, but never in the Infants Act. And as I say, you are really clearly bang on in saying that was not part of the intent. That I think that would have flown everybody over the cuckoo's nest back then, right? But that also shows how far we've escalated and how fast, right?
Right. And so this is back to this judicial accountability thing.
Right.
If it's easy to establish that this was not part of the original intent, a responsible, accountable court would say something to the effect of, no, that was not the intent of this law. If you want to have a law that facilitates that, you need to go, modify this law or pass a new law. But as it stands, we can't, these procedures were never intended to be part of that. But our courts are just sort of, not. I think that's my impression is that the courts are doing what the establishment expects them to do. Right.
But then that is so true on so many fronts. There's something weird going on with our courts. The case involving the father, that should have been clearly. Well, there was so much disturbing about that. I mean, the first judge in the case, Bowden, was clueless about all the language associated with transitioning and what was transpiring in this case. And I remember Barbara Finley standing up and saying, "Don't worry, my lord, you'll get it," but then the next day he came back well versed. So there's a manual there somewhere, and I know we've got the manual for the judiciary out of the UK. Regrettably, our freedom of information laws don't allow us to access what is transpiring behind the curtains, the iron curtains of our judicial halls, the halls of decision and fate. But
right. So
yeah.
that's another question. If there's actually, and there shouldn't be, discussions going on between the judiciary and what we'll call members of the establishment, because I had kind of a similar experience myself, and I'm sure the person I'm about to mention, but I was at one point, people think now that I just do YouTube shows and stuff. I used to be very politically involved, trying to pressure, and I got involved with school boards and trying to talk to MLAs, and we've sent out information packages to MPs all across Canada. And in the process of that, I ended up getting an appointment with the Speaker of the House, Darryl Plecas. And so I went to his office and I had probably a good 45-minute discussion with him. And that was sort of during the early phase of my calling for provincial and national inquiries into the transitioning of vulnerable children. And so basically I got an appointment with him to discuss this and to say, listen, this is a serious issue. I'm not saying change the law. I'm saying we need to have an inquiry into whether or not the law should be changed. And this is something that's worthy to be put on the floor. And we need an MLA or somebody to bring this to the floor of the legislature. So I had a 45-minute discussion with him where I laid it all out. And by the end of that discussion, he was like almost jaw dropped. He was like, wow, yeah, this is it's quite clear that what you're talking about, this needs to be investigated, because I had brought up the stuff about, we don't know the actual numbers, but huge percentages, a disproportionate percentage of foster children are identifying as transgender. And as a former foster child myself, of course, this is very a personal thing to me. And so I gave him all of these startling numbers and, autism rates for transgender kids, and, the fact that so many of these kids have psychological and emotional problems. And I laid it all out for him, gave him all the numbers. And at the end, like I say, jaw dropped. And he was saying, yeah, this definitely needs to go to the legislature. I'm the speaker. I can't really put it to the floor myself, but I can sort of put you into connection with the people who will do that. And he had said to me, like in no uncertain terms, he had said to me that your initiative to get an inquiry into what is happening will not fail. This will happen. This is what he told me. Okay. And so by the time I got done that meeting, and people should know that Darryl Plecas is the Speaker of the House in the BC legislature, right? So I was feeling pretty good. It's going, all right, finally, we got some motion.
He's got friends in all those places that could have achieved that. Yeah.
Right. So I went away thinking, all right, we're going to get this ball in motion and maybe we'll get this inquiry. The next big thing will be to keep the inquiry clean itself, because I know the UK has an inquiry. And when the UK launched their inquiry, when I first looked at it, the first thing I noticed was the person they had appointed as the head of the inquiry, had all kinds of ties to the pharmaceutical industry. And I was like, okay, what are you guys doing?
No.
So that, but I'm aware of that. So if we get an inquiry here at some point, I'll be all over that like a hawk from the initial stages if we can get it. But what happened was that a couple of days after I talked to him, he contacted me and said, well, I know I had told you that you weren't going to fail, but I had a discussion with somebody, and all I can really say is that I don't really feel that your case has any merit, and we're not going to be able to follow through on this. And that's about all I have to say. And it was done. So 2 days later, he'd gone off and he'd talked to somebody from basically saying I would not fail, and this would make it to the floor of the legislature. Just complete 180, and suddenly, nope, this isn't going anywhere. Everything you said is invalid, and there's no more to say about it. So that's that whole thing about talking to people behind the scenes, and are those kinds of discussions going on between the judiciary and people in power? If they are.
Where the problem with the judiciary, this is what we do know, Jen, is that there are so many meetings for lawyers prior to becoming judges on these things. I mean, you've got like West Coast Leaf, right? The radical feminist organization that's very pro-trans. And one of those judges, they, as lawyers, they go through all these, community meetings where they get indoctrinated with this insanity. Then they're appointed to preside over cases because they know about these issues, as in the case involving the father. But more than that, judges training. I have a copy of minutes from the provincial court when Barbara Finley wanted a meeting with them to further, and talk about homosexual rights, right? So, some of this information comes and, we'll do an expose on it, who's whispering in the king's ear, right, on these issues. And anybody with any common sense has to start listening to the facts on this. What transpired in the case involving the 14-year-old girl in BC here, now 15, is just a comedy of judicial bungling. I don't know if they really understand how stupid they look, but I intend to make sure that they understand how stupid they look, because that case, not to hear the expert evidence, not to adhere to the fact that the Infants Act was brought in without, acknowledging that cosmetic surgery and sterilization were not to be part of it, not to just look at all the circumstances around a 14-year-old girl, the tribulation she was already going in, the psychologist that failed to investigate any of the family situation. I mean, it just goes on, and it's sad, but our greatest hope is that when that child does decide, and hopefully she will, to detransition, that we can sue all the experts that were involved. And, I think it's time that there's a move to be able to sue the judges as well. In this case, complete negligence on their behalf.
Right. Well, on that note, something else. So into these sort of secret meetings and stuff. So federal lobbying by pharmaceutical companies in Ottawa, there's been a significant change here. Okay, so there is an office that monitors this. It's called the Office of the Commissioner for the Lobbying of Canada. Right. And they keep track of the number of meetings taking place between pharmaceutical executives and government. And what we can see here is between 2008 and 2018, that went way up. So from 15 in 2008 to 104 meetings in 2018, and maybe more now. And is it just a coincidence that in that same time frame we see all of this massive these massive projects really that are benefiting the pharmaceutical industry, whether we're talking about the transgender agenda or now talking about universal vaccination, right? Is it just a coincidence that these meetings have been going through the roof? And that's the other thing there is there's something rotten going on where we need to sort of we need to purge this type of stuff and set up systems where this can't happen anymore.
So last year on this subject, and those are the meetings that we know about, okay? And
right.
I'll talk about the provincial meetings here soon. But last year I got a call from one of the high-ups within the Federal Conservative Party of Canada, outraged over a convention or a large meeting that had over 100 tables. Each table was sponsored by a pharmaceutical company. This is the federal conservatives, right? And at their convention, each table was funded and people invited as a result of their sponsorship of this thing. So, that's the entrenchment that we're getting on the political infiltration. Now, in BC, the ARC Foundation, which we're all very familiar with, and that was actually one of the questions that I asked Robert Quartermain, whether or not who's a trustee with the ARC Foundation, who's responsible for bringing in SOGI, did he have any portfolio investments with the pharmaceutical companies? But I looked at the lobbying records for the government for the 3 years previous to SOGI being adopted and now paid for, with the BC Minister of Education. And you know what? Not one of the people that was instrumental in getting SOGI in was registered as a lobbyist. So we're doing something wrong, Jen. If we can't be lobbyists and get our things done, we need to find out what these people are doing who are not registered as lobbyists, but somehow have access to all the children in the BC public education system.
Right, and it's just a serious problem. So when I present sort of statistics like that, and like I say, when I started focusing on big pharma, that's when the pressure really started coming down on me. But when I present statistics like that, those are not only, or should they be considered instructive to the average citizen, and alarming, I would say, to the average citizen, but it helps to explain things. So lots of like top intellectuals, so say one of my favorite intellectuals, Noam Chomsky, or the physicist Richard Feynman, they have both said that whenever you're looking to understand a problem or solve a problem, the first thing that you need to do in that process is when you're listening to a theory, right? Don't pay any attention to the letters that appear after the name of the person putting forward the theories. Don't pay any attention to, what titles they hold. The first thing you need to do is you need to ask, does it make sense?
Yeah.
Okay. So when you've got people coming to you and saying, well, boys are actually girls, or girls are actually boys, that's where the discussion should stop. And I had this debate recently with a lawyer who's been sort of involved in this, and he was basically arguing that we have to look for some sort of middle ground here and sort of deal with the realities.
Compromise. Yeah.
Yeah, compromise. And I said, well, yes, okay, I express in a transgender way, so I'm obviously not against particularly adults expressing transgender if they want. No problem. Go right ahead, as long as you're not trampling other people's rights. So as long as I'm not saying, okay, I am a woman, so I'm going to follow you into the swimming pool change room, Kari.
Yeah.
No, right? No, I need to, that's not acceptable. So for me, yes, we need to try to be as compassionate and understanding as we can about a community that, and this is an important stat that I don't put out there to attack transgender people, but there's a lot of mental health issues in the transgender community. Okay, and so many of the discussions that go on out there avoid this topic, right?
Well,
but it's,
and Jen, on that, not even limited to mental health, there's a lot of other issues. And so if we're going to have this discussion, let's have a broad, honest, forthright, let's not narrow it down to a fantasy vision of what it is to be trans. Let's look at all the issues that go along with it, whether it's sex addiction, mental health, all those kinds of things that are not limited to one person, because everybody has different motivating factors, right? But we need to have that honest discussion. If we're going to do this, let's look at all the factors and let's be brutally honest about it. But as you know, it's not about that. It's about the money. It's about increasing power. It's about reputation, and it's not about the kids. That's for sure.
Right. So, but like in my discussion with this lawyer, he has basically was referring to some other discussions that were going on, but those discussions at no point dealt with reality, physical reality. And I said, okay, well, they're making some wonderful points and stuff, but from my perspective, if we're going to have a productive discussion and negotiation in terms of laws and stuff, we have to set the foundation on knowable, testable physical reality. Okay. It is not a crime. In fact, it is a fundamental truth. That's one of these truths that should be considered so fundamental that they don't even require expression. But
Right.
Unfortunately, at this point, we do need
Here we
to
are.
say,
Yeah.
yeah, the fundamental fact and truth is that a male cannot become a female. A man is not a woman. A boy is not a girl. Now, if they want to express in the world in feminine or masculine ways, that's a whole separate issue. But the discussion that we have has to start with physical reality. You got to set that foundation. And I said to him, I said, listen, I'm not willing to enter into a discussion until we admit the truth. Okay, this is an important truth that we have to be strong enough and honest enough to admit and understand that it matters. So that foundation, once it's laid, then we can start having all of these other discussions. But even like lawyers who are supposed to be on our side of the debate are saying, well, that's not really an issue. It is an issue.
Yeah, but I think, Jen, it's because we've become this, oh, we don't want to offend, it's the conditioning of the populace, right? And whether it's on these issues and whether you're conditioned out of fear or compliance, right? Because you're just an easygoing person. Once you start skewing reality, we have problems. I mean, once you start allowing, and I know you're very eloquent on this speech and you're bang on this, men who identify as women now being able to skew the statistics on women and HIV stats. Like, you lose the whole basis of our society as far as what we're trying to do when we want to understand things like a pandemic, for instance. And so where do we end up with that except la la land and, trying to make information based on information that's not worth the paper it's written on. So, to watch the conditioning and what has transpired and to see, trained legal minds willing to just bend out of this way because they don't want to be offending people and that kind of thing. If you look at what has transpired, like you're doing an awesome job looking at what has contributed, did the Infants Act do this? What motivated this? Let's look at the last 20 years of how we've been conditioned to speak, how we've been conditioned on what we can say or not say. You and I are not homophobic. We're not transphobic. We're just rather logically inclined people who don't like to waste time with, pandering words, right? And we like truth. I like truth, even when truth hurts. At least it's a baseline you can stand on. But we as a society have just been conditioned over the years, and this is where you have to justify yourself that you're not homophobic instead of people proving that you are, or transphobic, because I love it when they call you transphobic. I just think that's the best, right? If there wasn't a good example.
It must be my skirt that makes them think I'm a transphobe.
Jen, you really need to fix that, my dear friend. But, I think we just need to have a call back to sanity. We have to have a call back where people will speak up. I look at some of the cases, like the Kimberly Nixon case, for instance, probably one of the first most important cases dealing with trans rights in BC. And I watch how the judges wrangle with the whole thing on how to address Nixon. And they say out of respect, but they only gave so much respect when it came to Kimberly. Now, this was the case, just for your viewers who are not familiar. This is a sex worker who wanted to be a counselor at a rape shelter. And the rape shelter said, no, these women come in, they've already been hurt by men, they need to be counseled by women. And they took umbrage with that, and Barbara Findlay again was in the center of that storm. Everywhere. And then went to the Human Rights Commission, which sided, saying, oh yes, how could you hurt this poor girl's feelings, this enlarged man, right? And found Vancouver Rape Relief. They fined them, I think, about $7,000 at the time. Well, fortunately, Vancouver Rape Relief said, no, we're not going to deal with this. We're going to go up to the Supreme Court of BC. It did eventually go up to the Court of Appeal. But when you read the decision in the BC Supreme Court, it's really good. They recognize this is the first time that transgender identity was recognized as part of being sexual identity. We didn't need to bring in all this gender identity and gender expression. Transgender people were already protected as a result of the Nixon case, because they said, no, this is your sexual orientation. That's part of where that umbrella of protection was given. That was back in 1996. So all these politicians have lied to us. Christy Clark, Trudeau, all this nonsense. It's never been necessary to bring in gender identity expression specific protection. It was already there. But the wisdom in the case and was really good. And the justice said, your rights stop where women's rights begin. You can't, in other words, you can't supersede the rights of somebody else. And so they found in favor of Vancouver Rape Relief, and Kimberly Nixon, and as a male, could not counsel women. So very logic. Now, regrettably, that logic is no longer evident, Jen. And you know, what has transpired since then, I don't know. But, you know, as you say, the machinery of democracy has to be cleaned, right? Because democracy is founded upon the rule of law. So that includes the judiciary, our legislators. And, you know, I think it's sad to say we are leadership deficient in our society and our communities. People who just go along with the flow and what's easy and compromise, don't want to offend, are destroying this nation. And it's going to be for good people. And I know you're leading the charge, your viewers. We need to find ways to do that. And, you know, you talked about writing letters to MLAs. You talked about all those things. I watch right now as, you know, the people that are viewed as working diligently on issues, whether it's, you know, let us out of our houses on COVID-19, or, you know, the issues around the counseling against transitioning and those kinds of things, writing letters, all these things. Well, I think the most important letter people can be writing, and I do like letters, is to your friends and family and neighbors. And the one letter you can put off to your elected official is to say, I will not vote for anyone who engages or stands or moves forward these agendas, and the agenda to undermine family, to undermine parental rights, to destroy children's identity. You know, list them all out. But the closing remark is, be advised that all my letter writing campaign are going to be to my friends, encouraging them to vote if we can find somebody who has the leadership qualities to make these come to fruition, Jen. You know, these are simple acts. We can amend the Infants Act and eradicate it, take it back to 18, or put it to a council of people, not just one doctor who has his pockets lined with a child transitioning. We can bring in things like the Emergency Programs Act, which is all this insanity is ensuing. I raised 20 years ago, if you look at Emergency Programs Act, there's one thing really problematic about that act, that emergency isn't defined. They can define it any way they want to. That's dangerous for us as a nation when we don't have good leaders that are wise and discerning and truly care for the freedoms and liberties of the people. The act allowing for child apprehension, the Child and Family Services Act, that can be changed. You can't just have this long list that says, oh, if a parent emotionally harms their child, the child has the right, or they have the right, the state has the right to come in and remove your child. Well, sorry, when I was raising my teenagers, it was my duty to emotionally harm them on occasion, right? Especially when they wanted to go out and drink and do partying and that kind of stuff. And they were, trust me, very emotionally harmed. Putting the tools back to parents, the School Act. We have the ability to write the School Act and recognize parental rights. All of these things can be done quickly if we, as logically sane people who are fed up with the insanity and lunacy, who truly care about kids, get our act together, unite, and find leadership within our communities that we want to be our voices in government. That will clean those spark plugs of the machinery on the machinery of democracy.
Okay, so that's a nice segue into the other topic that I wanted to discuss briefly here. But just to sort of punctuate that this discussion on the whole transgender thing, is that I'm frequently called hateful and mean and stuff because I won't refer to Morgane Auger as a woman. right? I get so much anger that, oh, you're just so mean and stuff. And why do you have to be mean? And my response has always been, listen, this isn't about being mean. It's about recognizing truth. Okay. And that is important. And when you're talking about the law, okay, so we live in a very diverse society, all kinds of people with different religions, different philosophies, different views, a very diverse society. The only way that you can keep a society that diverse ordered is by making sure that your laws are tethered on knowable, testable, physical reality and truth. And this is what I said to the court when I was in the court. And I was a little worried that he was going to, slap me with a contempt charge when I said it. But what I said was that in the previous case of this father who's been forced to facilitate his daughter's gender transition, he had also instilled as under order to refer to his daughter as a son, as a male, and use male pronouns and stuff. And I said, what we got going on here is we have got the court in a situation where it is forcing its citizens to speak lies. Yeah. Because what has happened is justice at this point in time has untethered itself from truth and reality. And the moment that the courts untether themselves from truth and reality, they also untether themselves from justice. That's my basic premise. And when I speak to people about this over and over again, I say, listen, you just need to understand that truth is not hatred. Okay. It's an important grounding thing.